Begin. So hello, everybody. I'm Athura Mathur, the Director of Legal Research at the Center for Art Law, and I'm really excited to welcome you to our Artist-Dealer Relationships Clinic. I would like to thank our network of volunteer professionals and attorneys without whom all of these sessions would just not be possible. And before I introduce our wonderful keynote speaker for today, I wanted to introduce you to the center and let you know a little bit more about what we do. We are a Brooklyn-based research and education nonprofit, and we're dedicated to offering resources and programming to advance the arts and law community. Through our website, our newsletter, our events, we try to disseminate information and keep our audience updated on everything art law, whether it's news, programs, cases, publications, movies, and a lot more. So we facilitate a ton of conversations by hosting and participating in events such as ours today. And of course, this doesn't even begin to describe everything that we do. So I'd invite you to take a look at our newsletter and subscribe to receive updates if you haven't already. You may also consider becoming a premium member to receive offers and discounts for our upcoming events and access to our case law corner, articles, and the recordings of all of our past events. I'm also very excited to announce our upcoming events. We have a conversation on copyright infringement, fair use, and how to issue and respond to DMCA takedown notices. We also have a workshop, which is more practical, on how to file a claim with the Copyright Claims Board, which is the small court claims. We also have a workshop on planning an artist's estate and preserving archives, as well as our legacy and estate planning clinic, which we once again have one-on-one consultations pairing our artists and network of attorneys and art professionals, so different answers can be given to concerns in legacy and estate. These are all mostly up on our website, so please do take a look, and I hope to see you at hopefully all of them. A few of the general housekeeping matters for today. The keynote presentation is being recorded, but as I mentioned, we'd love to see more of you, so please feel free to keep your cameras on, but your microphones muted for the moment. And to those of you who have registered for the consultation sessions, we will begin at 6 p.m. and we'll assign breakout rooms for the sessions. And after the event, we'll send across a handbook for the clinic that contains resources on artist-dealer relationships, on contracts, and the bios of all of the attorneys and professionals who are with us today, along with a recording of the keynote session. If you have any questions during the presentation, please put them in the chat box below. We'd love for this to be as interactive as possible, and we look forward to your participation. And now, finally, let me introduce our keynote speaker for today, Yaél Weitz, Counsel at Kaye Spiegler. Yaél advises clients in a wide range of domestic and cross-border art and cultural property matters. She's represented claimants seeking restitution of art misappropriated during the Holocaust and claimants seeking the recovery of looted or stolen cultural patrimony. She's also represented several collectors and galleries in various art transactions, and you can read the many, many wonderful things that she's done in the full bio in the handout, which is going to be sent across shortly. But without any further ado, I will hand it over to you, Yaél. Thank you so much for being here and for presenting for all of us today.
Well, thank you, Athura. That was such a nice intro. And it's great to see you all. As Athura mentioned, I'm Yaél, counsel at the law firm Kaye Spiegler, but also a member of the advisory board for the Center of Art Law, which is always a great pleasure. And I'm pleased to welcome you to today's Artist-Dealer Relationship Clinic. And before I get started, I'm just going to share my screen. Sorry. Oops. And while I'm doing that, I just wanted to say, was it that work? Hold on a second. Okay. Does that look okay? Can you see it?
Looks
all right.
Good. Thank you.
Okay, great. So as Athura mentioned, I'm gonna do my presentation, but feel free, please, to interject with questions as we go. I'm happy to stop and address questions as they come up, or we can always chat more at the end. Okay, so in recent years, we've seen changes in the art market that have affected the relationship between artists and dealers. And in large part, this shift, as I see it, is a result of social media platforms such as Instagram, which allow artists to interface directly with collectors and have given artists more control in marketing their art. These platforms have, in some cases, been credited with launching careers of artists who previously would have needed to rely exclusively on gallery representation. But at the same time, galleries are also using these platforms to promote works by artists they represent, which in turn can create more demand for artists, both to produce art, for gallery websites, but also for display at the gallery or at one of the many art fairs, which hopefully some of you are getting a chance to attend here in New York. So the agreement between the artist and the dealer, which I'll focus on today, is critical to capturing this evolving relationship, but also numerous other terms setting forth each party's respective obligations. And I'll go over several of those, and I expect other terms will come up in your clinic sessions. Traditionally, the relationship between the artist and dealer can take a couple of different forms. The first is where a dealer buys an artwork from the artist outright for purposes of resale. This agreement type of arrangement is less common in the US, where more often galleries prefer not to acquire the art, which is usually considered a riskier option and can be considered a financial burden to the gallery. So the second type of agreement, which is more common, and that I'll be focusing on, is an artist-dealer representation agreement, where the artworks are consigned to the dealer, typically on some sort of exclusive basis, pursuant to agreed-upon conditions. In this type of arrangement, in contrast to the first, title to the artwork remains with the artist throughout the duration of their agreement, up until the moment that the artwork is sold. And this arrangement is often favored not only by dealers in the US, but also by artists who can benefit from having their artwork sold and marketed by professional dealers, if that's, the focus that they're looking for, and also giving them more time to focus on their art. A third type of arrangement I'll just mention is also a consignment agreement, but for a more limited transaction, such as where an artist wants to consign certain artworks to a gallery, but maybe for a particular exhibition. In each type of these arrangements, the agreement between the dealer and the artist should be memorialized in a written contract. And this is critically important, both to protect the artist and the dealer. We know that the art world often operates on a handshake basis, but a written consignment is essential. And also, I'll just mention that oral agreements can often be unenforceable depending on the type of agreement involved and, the jurisdiction that's governing. So the contract doesn't have to be complex, but it should include the essential terms to avoid disagreements down the line. So before I move on to discussing some of the particulars involved in consigning or pursuant to an artist-dealer representation agreement, I thought it'd be helpful to spend a few minutes discussing the relationship between the artist and dealer that's created by a consignment. So in New York, we have the Arts and Cultural Affairs Law, or NICAL, which provides a range of protections and regulations related to art transactions conducted in the state, with Section 12.01, which you can see here, protecting the rights of artists who consign their works to art dealers or galleries. There we go, and that's more of that law. So one of the more important aspects of this law is that it requires that the artworks and their proceeds be treated by the dealer as a trust for the benefit of the artist, and the dealer is deemed a fiduciary for these purposes. So this means that the artwork and any proceeds from the sale are treated as the sole property of the artist, held in trust by the dealer for the artist's sole benefit. So the funds can't be commingled with any of the dealer's property and can't be subject to any claims by his or her creditors. So even if the gallery goes bankrupt, the consigned artworks won't be part of the gallery's bankruptcy estate. The provision applies not just to the artist, but also the artist's successor in interest. And you can see here how the law defines it as a personal representative, testamentary beneficiary, trustee or beneficiary of a lifetime trust, or an heir. The law also submits the dealer to fiduciary requirements of Section 11.16 of the Estates, Powers, and Trusts Law of New York. And that law requires the consignee, or the dealer, to segregate the trust property from his or her individual property, and states that any person who violates its provisions is guilty of a misdemeanor. So art dealers who commingle funds belonging to the artist can actually be criminally charged for violating the statute. Subsection 3 of the law also provides a private right of action for aggrieved consignors to sue for injunctive relief to stop unlawful conduct and recovery of actual damages. And interestingly, if the artist or the artist's successor prevails, a court may award reasonable attorney's fees. This is notable because traditionally in the US, each party bears its own attorney's fees regardless of who wins. So this is some added protection there. And finally, NYCL provides for a waiver provision under certain circumstances. The waiver must be clear and conspicuous and signed by the artist, and must specifically apprise the artist that he or she is waiving rights with respect to the proceeds from the sale of the consignor's work. There's other restrictions on waivers. You can read them here in the slide. And I'll just say, although these provisions are fairly restricted, artists should carefully review any waivers in the consignment agreement to ensure that they're not signing away protections that are otherwise provided for in the law. So the law is clear that delivery of art to an art dealer by an artist or her successors establishes this consignment relationship, and the dealer is deemed an agent and fiduciary with respect to those artworks. And as such, the dealer owes the artist a variety of duties. So for example, the dealer must care for and manage the consigned property prudently, avoid conflicts of interest, and account periodically to the artist regarding any disposition of the artworks. I just wanted to pause for a second and make sure there weren't any questions. If not, I'll keep going. Okay. So a good case in point that outlines some of these duties so that you have an idea of what it looks like in practice is Hirschfeld versus Margot Fiden Galleries. In 2000, the notable cartoonist Al Hirschfeld filed suit against Margot Fiden Galleries, seeking injunctive relief to bar Fiden from disposing of consigned work by Hirschfeld without his consent, and he requested a full inventory and accounting. The complaint alleged other causes of action, including breach of fiduciary duty, breach of contract, and others. And the court initially issued a TRO and then granted the injunctive relief. So here, the relationship between the artist and the gallery began in the early 70s when Hirschfeld consigned a few of his works to the gallery. They then entered into a formal agreement in which he consigned all his original art to Fiden. The agreement also covered artworks not yet created, where prospective buyers agreed to purchase drawings from Hirschfeld in advance. And upon the sale of any artwork, Hirschfeld received a mutually agreed upon payment from Fiden. So this agreement gave the gallery an exclusive right to sell the artist's works, And this is something that we'll come back to shortly. The agreement also guaranteed Hirschfeld a $10,000 payment each year, which would automatically, and the agreement would automatically extend each year if he got at least $12,000 during that prior year. But while the gallery obtained the right to terminate the agreement, the artist did not. Even so, this arrangement continued for more than 2 decades before the relationship took a turn for the worse. In the 90s, Hirschfeld alleged that Fiden refused to follow his instructions regarding disposition of artwork, including by refusing to return drawings to him when he requested, and that Fiden sought to prevent 2 retrospectives of his work, in part due to her own personal animosity towards someone involved in the exhibitions, and that he also alleged that she refused to provide him with documentation and records concerning the artworks. So the court held that under the meaning of NYCAL section 12.01 that we were looking at, Fiden was deemed to be an agent of the consignor, and the artworks were trust property held for the benefit of the artist. So as an agent, Fiden was bound to act according to Hirschfeld's instructions concerning the works. Here there was evidence suggesting that she didn't, because she tried to block those 2 exhibitions. And the court also ordered the gallery to provide the full inventory and a full accounting. And the gallery was also ordered to obtain appropriate insurance for the consigned works, and naming Hirschfeld as an additional insured. Ultimately, the case didn't go to trial. The parties settled, and in the postscript, various proceedings followed. They sued again in 2016, and then again, there were proceedings in 2018 and 19, so the saga continued. So with that, I'm going to turn now to the consignment contract itself. And I have here a slide of the exact typewriter that, no, I'm kidding. So let's talk about the agreement, which I know is always of interest to everybody. There's numerous provisions that can be included depending on the specifics of the relationship. And I'll cover some of the significant aspects of the agreement. I'm sorry. Okay, so one of the most critical functions of the consignment contract is setting forth the parameters of the agency relationship and whether the gallery has the exclusive right to sell the artist's artworks or whether the gallery has exclusive agency. If the dealer has the latter, meaning that the dealer is given the right to be the artist's exclusive agent, this leaves open the possibility that the artist could sell her own work without paying a commission to the dealer. If, on the other hand, the dealer is given the exclusive right to sell the artworks, an artist must pay commission to the dealer from a sale, even if the dealer wasn't involved in the transaction. And artists and dealers can agree to more specific terms regarding the scope of exclusivity. For example, allowing the artist to sell to family, to barter artworks without paying commission, or maybe like a lower commission in those examples. Or also if, the artist is selling directly versus via social media. I mean, these are all things that can be incorporated into the contract. And you can also limit it by a particular geographic area. So, for example, a gallery's scope could be limited to New York or just the East Coast, allowing the artist to enter into a separate agreement, maybe for a different geographic location. Another critical aspect is the duration of the relationship between the artist and dealer. The parties may want to provide for options to extend the term. If that's the case, you would also want to include that. An agreement should also be clear about identifying the artworks to be consigned, including specific descriptions. And it should also include which party is going to assume the cost of packing and shipping the artworks to the gallery, which, if you're dealing with very big or heavy artworks can really be significant, and it can add up. And also the artist will want to ensure how the gallery is storing these artworks, and insurance as well. And actually, on the insurance point, it should clearly state if the gallery is going to insure it, because it's not required under law, but it is generally recommended. And even though it can be expensive for galleries, and there's specifics that you might want to include on that point. The agreement should also discuss pricing. Typically, the artist and the gallery will jointly determine prices for our work, though some artists may defer to the gallery, which may prefer to set the pricing for the artworks. But in any case, the agreement should provide for periodic review of prices to take into account changes in the artist's reputation or the market. And the artist and dealer may also consider addressing discounts and whether the gallery may be permitted to apply discounts, let's say 10% or 20%, without consulting the artist for approval. Likewise, the agreement should provide for the gallery's commission on art sales, and how often the gallery must pay the artist once money is received. It can range from as low as 25% to 60%, depending on the circumstances involved. So, these are only some. There's obviously a whole host of considerations that you'd want to take into account. And so, and I think, as you go into the rest of the clinic, you'll probably hear more about those specifics. So, I think the important thing to remember is that you carefully review the agreement, and especially any waiver provisions in the consignment, to ensure that you're not, signing away any protections. So I guess I'll end with the saying, better safe than sorry. So thank you very much.
Thank you so much, Yaél. We really appreciate that presentation. I think it sets a good base for the consultations that are to come. If anybody has any questions, please put them in the chat. A couple of questions that may be on our mind is, in all of these contracts, what do you think are the most common mistakes or challenges that artists seem to make, or things that they sign away and realize later? Do you have any list of common mistakes made?
Oh, that's a good question. I don't know what would be the most common mistake. I think very generally, I would just say, so often, as an attorney, people come to me after there's already an issue. And I guess my answer to that would be, figure out in advance, what you need. And if possible, consult with an attorney, because I think, while it is an expense, you're better off avoiding the problems than, trying to deal with it after the fact. So.
Thank you. And in a lot of maybe the consignment agreements, or even in commission agreements or other types of art contracts, are there any red flags that you would advise artists to look out for? I know sometimes the terms like exclusivity, or the length of a contract, or assignment or transfer of copyright, those are more in terms of licensing, but these are usually some things that stand out in these type of contracts. Are there any red flags that should be on the radar for artists?
Yeah, I mean, I would think about, is the contract balanced? I know that it can it can sometimes be an uneven playing field in this context. But I do think that it's important that the contract not seem overly in favor of, let's say, the gallery, if you're looking at it from the artist's perspective, and that there's kind of, you know, provisions that allow you to reevaluate. So let's say you agree on a particular commission, maybe you want to have it so that, that only lasts for a certain number of months or a certain number of time, amount of time, so that the artist can then go back and say, okay, maybe that didn't work for me. It gives you, an opportunity to revisit some of those terms. And I think, it's really going to depend on the priorities for the artist, I think, but there's certain baseline things like, insurance is a big thing. I think you'd probably want to make sure that the works are insured, and that, that you're named as the, additional insurance, so the proceeds are actually getting to you. And that's something to think about, in a consignment context, because the artist is holding on to title there. It's not, so they want to make sure they're protected. So there's different things.
Thank you. And are there any other questions from the audience? Or, well, I do have a couple more then to follow up. So, so you had mentioned that it would be good for artists to get in touch with an attorney and kind of lay out what the next steps are before an issue comes up. But when do you think is the appropriate time for artists to begin working with attorneys? Is it the minute that they want to showcase their work, or when they receive an offer? What's the right time for that step to take place?
Well, I would say that, I think when you get to the point where you're agreeing on the specifics of the arrangement, and you want, I think an attorney, I mean, again, I understand, that it might depend on scope and, the particular, particularities of that deal, right? If it's for a show, or like, how, what are you getting yourself into? But I think if you're getting into a relationship that's going to be long-term, you probably want an attorney to help you negotiate that relationship. But certainly if not at that point, then when you're ready to enter into an agreement, and put something down in paper, I think that's definitely a critical point.
Great, thank you. And if suppose an artist is already represented by a gallerist, and they're not too happy with that artist, what would you recommend the next steps be? Or apart from that, what should they keep in mind if they're starting to search for a new gallery, on how to maybe deal with their current gallerist, maybe terminate that relationship, and what to keep in mind when they're looking for new representation?
Oh, that's a good question. I mean, I think, I don't mean to speak in generalities, but I think it would probably depend in part in what went wrong, right? I think if there were specific things in the relationship, maybe the gallery wasn't marketing them enough, or, just not, I can't think of the other, just whatever was the issue, you would want to remedy that in your next go around. And I think be thoughtful about, how you negotiate that next agreement, and keeping in mind, what didn't go so well the first time around. Like if it was an issue that they never paid for shipping, or whatever it was, you wouldn't want to make that, your kind of your big point, I think, for the next one.
And finally, I know I've asked a bunch of questions, but to conclude, what do you think are a couple of good resources for artists to keep in mind? I know that there is, you have the art law treatise, which has sample contracts and template agreements. Do you think there are any other resources or articles or links or just organizations that could help provide those kind of templates or just basic information before proceeding with a lawyer and getting a general idea of what should be done?
Yeah, I mean, you know, I I can't think of particular organizations off the top of my head right now, other than the Center of Art Law, of course, which is an amazing resource, really, genuinely. But I think the art law books that you mentioned. But that I think that there's other not-for-profit organizations that will post things online for artists, but I don't have off the top of my head, I'm not sure of the names. So
Perfect. Thank you so much, Yael. And you and all of the participants, you can check our resources and the handout for some of the books and some of the links that we just mentioned, including the art law treatise, which does have a good number of sample contracts. And I think in the handouts, we've also included just a couple of general links to consignment templates. So in case those are helpful, you can take a look. And if you have more questions, you can just reach out to me or hopefully Yael as well, and we'll be able to answer those. But thank you so much, Yael, for your presentation and for answering all the questions. I know that I found this incredibly insightful and it gives us a good amount to think about. And as I mentioned before, I think this sets a strong base for the next part of the clinic. So we really appreciate you being with us today. Thank you so much.
thank you. It was a pleasure.
Thank you. And to the attendees who are staying on, and for the ones who will be leaving right now, thank you so much for coming to the session. I'll be sending across a survey soon that I would love for you to fill out, and the recording of the keynote will also be sent across shortly. We really appreciate your participation and hope to see you at future center events. We're going to begin the consultation session soon. So those of you who registered for the sessions, you can stay, and I will be assigning you to a breakout room with the professionals. So I hope you all received an email with your time slot and the assigned professional. In case your time slot is a little later, you're welcome to log off and log in closer to the time of your consultation. Otherwise, feel free to stay over here with us. And as a reminder, the sessions are capped at 20 minutes. So it would be wonderful to follow those time bounds so that we can proceed with the rest of the consultations in good time as well. So I've just opened the breakout room. So hopefully those of you assigned should have got a notification. Bye. Thank you so much, Apel, for attending.